The California Residential Purchase Agreement form is the cornerstone of every successful real estate transaction in the state of California. In this training video, we will review how to properly complete and use the RPA form step by step to better serve and protect yourself and your clients. This training is not intended to be a substitute for the advice of your broker, nor that of your attorney. We will cover paragraphs 23, 24, 25, 26, 27, and 28. Our instructor for this video is Kevin Burke. Let's get started.
Let's get on to it. All right, let's talk about selection of service providers. And this is kind of fun stuff. So I've got my annotator going. You all know I love my annotator. So we're going to talk about paragraph number 23, selection of service providers. This is like the most misunderstood thing out there, okay? So who selects who the service providers are supposed to be? Think about it for a second. So in practicum, it's supposed to be the parties, right? The buyer and the seller. And yet we know in our practice of real estate that it's like one of the biggest fights we have, all right? And I'm sorry, I'm guilty, because you know what? I get my service providers probably 97, 98% of the time. I'm going to use my escrow company. I'm going to use my title company. I just closed a transaction 2 days ago, yesterday. They're all running together. We have a lot of closings. So, close a transaction where the seller actually said, I want to use this title company and this escrow company. Okay, he picked it. All right. I said, I got people that I have are my favorites, but if that's your choice, that's your choice. He said, I'm selling property all over the country. You know something? He will never use them again. I busted up. It was such a disaster. It was a freight wreck. And it's like, God, we do hundreds of transactions all over the country, every week, and we always use them. This was a disaster. Okay. All right. So anyway, bottom line is, I have my favorites. I have people I like to work with for service providers, but let's take a look at what the contract says. And then I want to tell you a little bit about what the law says. Okay. There's this little law called 15 U.S. Code 2608. And I'll send you that. I should have put it in here. Darn it. If somebody will send me an email reminding me, I'll send it to David, and David will send it out to everybody. Okay. But it's this little thing called RESPA. Okay. And I'm going to tell you how important that is to you. Okay. So brokers do not guarantee the performance of any vendor, service, or product providers. Well, of course we don't. Listen, we don't have their credentials for one thing, and they do what they do. So here's how it is. All my college classes, I always taught it this way. I said, here's how it works. Here's this great big circle. And here, lender does loans, escrow does escrow, title does title. I have always felt like all I need to do is be the orchestrator. I just need to be the director of the orchestra. I'm the guy waving the baton and everybody else is playing. I think I'm the center of that world, okay? That says I will direct traffic, but I am not doing your job, okay? I'll do my job, right? And my job is to maybe direct traffic. Maybe that's what I do, okay? But at the end of the day, let your lender do the loans, let your escrow do the escrow, let your title do the title. And if you have a choice, use the ones that you're comfortable with. If you are not comfortable with the ones that you're using, send me an email. I will send you my approved vendor list. Listen, I go off of, SDAR has some great affiliates. And all the ones that I do business with happen to be affiliates of SDAR, not because I didn't choose them because they were. I had already chosen them only to find out that they were. And of course, that makes sense, right? If I like what they're doing, then so must SDAR like what they're doing. But I have my own approved vendor list. I have people I like to work with. I have a list of attorneys. I love these attorneys, right? Okay, these are people I refer to, okay, a lot, okay? All right, so I'm not going to guarantee their performance, all right? I'm not going to sit down and tell, and say, well, they should have done this or they should have done that. No, they do escrow. Escrow does escrow every day. I do escrow every day too, but I do it from a outside looking in. Okay, I can tell you why the contract says what it says. We went to the escrow, the big escrow company, the affiliate in the sky, and we said, how do you want our new RPA to look? What would make it easier for you? And they said, we want you to make it joint escrow instructions. Why don't you be the escrow instead of comparing us, our faxes with your faxes? Why don't we just make you the escrow instruction, and we'll be the people that follow your instruction, all right? Because what's all that is anyway, just a rewrite of the contract. Okay. All right. So that's why we do that. So no, we do not guarantee their performance. Okay. Now, then how come we get into such a fight? Watch this. Okay, whether referred by the broker or selected by the buyer, no matter who it is, okay? Listen, I want you to be the judge, all right? You be the judge that decides whether or not that service provider is a good one or it isn't. Remember that if you are insisting that your client use a particular service provider, you may not only have a problem with RESPA. Remember, if the seller requires the buyer to use a particular title company, the seller could be liable for treble damages. That essentially means 3 times the amount of the policy. Okay, are you willing to take that risk? You're the listing agent. The buyer comes to you and says, I want to use, XYZ title. And you say, well, I like to use, ABC title. And so did the seller make that decision or did you make that decision? Okay, give your client choices. So your buyer comes along and says, who should I use? And the answer is, I don't know. Okay, but I can answer the question, who do you use? So I like to use this one, or I'll send them my approved vendor list and say, here, pick one, whatever you like. Okay, so but at the end of the day, you're not going to be able to call me out on a negligent referral. And I know Jackie Oliver could be listening to this right now, great attorney. And she'd say exactly that. She'd say, yeah, that's right. Negligent referral. You send them only one, and that one turns out to be a freight wreck, you're going to go for that. Okay, it's going to be your fault. All right, that's just how it's going to work. Okay, so be careful about how, thou doth protest too much. Let's be careful about that. Okay, so when you're representing the buyer, ask your buyer, who do you want to use for escrow? Who do you want to use for title? Who do you want to use for home protection plan? Bingo, home protection plan. Okay, because sure enough, you recommend a home protection plan, and it doesn't cover something that happened in the house, and they find out later on that their plan would have. Okay, we're gonna have a problem. Okay, all right. And then likewise, I'm the listing agent. I want to be careful. I tell my seller, I like these people. These are the ones that I like to use. Okay, you use whoever you want to use, and hopefully we'll get our minds together on that. In most cases, you're the biggest influencer doing that. You're going to be the one that influences which service provider that they're going to use, but you got to be careful that you don't direct that traffic a little too well. You follow me on that? Okay. All right. Now. Okay, so seller or other person. Okay, so buyer and seller may select any providers of their own choosing. Now, in a lot of states, the escrow company and the title company are the same entity. So in Arizona, for example, escrow and title are the same group. In Virginia, they can be separate groups. In fact, in Virginia, the buyer can pick their own settlement. They call them settlement services, so their own escrow company, essentially. And the seller can use a completely different one. And the two of the companies talk to each other, and everything works out just fine. But like we have these problems mentally in Southern California that we think that that having those service providers to be the same thing. We separate them here too, right? Escrow and title in Southern California, but in Northern California, they're the same entity. Okay, so we all figure it out, we all get along, but at the end of the day, you got to be really careful. Be careful that you aren't too adamant about what it is you're looking for. Again, especially if you're the listing agent, you want to be able to defend yourself by saying the seller made that choice. I saw a contract in a property in Coronado a couple decades ago now, where there were 8 counter offers and they were all over the title company. There was nothing else in them. I mean, in the beginning, it's a smoke screen, right? A listing agent, you get the counter offer from the seller, and it's got all the stuff the seller wants, and then boom, escrow and title, which is usually the agent-driven thing, right? Okay, and then the buyer counters again, and my experience is, at most point, it dies at that point. Seller doesn't want to play anymore. They don't understand what the problem is with escrow and title. Let them have their escrow and title company. Okay, all right. So that's my experience. But when the seller is requiring title company, remember that there's that the law says that we see this in our REOs, right? If the REOs were requiring buyers to use particular settlement services, and so the REOs finally figured it out because they got nailed with RESPA, right? And so and by the way, RESPA is when there's a government insured loan. It doesn't apply to cash. So when there's a government insured loan, so VA, FHA, Fannie Mae, Freddie Mac, all those things, right? Okay, so. But REOs came back and said, okay, well, fine. We won't, we don't have a problem with you picking your own services, your own, escrow and title companies, but there is no requirement by law that we pay the bill. So they come back and say, you want to pick your own stuff, but you got to pay our side too. Great comeback, right? Well, they got tired of getting sued. Okay, so that's a lesson to us. Okay, all right. Okay, that's paragraph number 23. Any questions on any of that? Yeah, you're getting it deeper than normally you're going to get, but that's just, again, I've got that little problem. I'm a practitioner like you, and then I got that silly law degree too. Okay, let's take a look at paragraph number 24. Let's talk about multiple listing services, MLSs. Okay, isn't it amazing how much I could have made out of 23? All right, so in fact, 20 minutes. Okay, so brokers, this is MLS, brokers are authorized by the seller and the buyer, that's really not clear, to the MLS a pending sale and close of escrow. The sales price and other terms of this transaction shall be provided to the MLS to be published and disseminated to persons and entities authorized to use the information on terms approved by the MLS. So let me tell you, frankly, we sell your data. Okay, we started that cat came out of the chute a long time ago. When you put a listing in the multiple listing service, boom, off it goes into the internet, right? You know that, and some of us want that, some of us wish that we hadn't done that, but we're there. Okay, we've been doing it for decades. So I think we get 2 cents a page or something. It's not, I don't get it, right? But that's what your MLSs do. All right, all across the country, they all do that. They sell that information to third-party aggregators, syndicators, things like that. People that are going to use that data on the internet. Okay, so but we need everybody to understand that putting it in the multiple listing service is just the beginning of that event, what that thing is that's happening. Okay, so we're going to go ahead and put it in the MLS. Those people that we sell the data to have a contract that says you're allowed to do this with the data. Some of them, get cute, they put somebody else's picture next to your listing, and so then we had to come up with a comeback for that. We created advertising remarks. That's something that is required to be made public. And even though they put somebody else's picture next to your listing, you have a right in the advertising remarks to talk about yourself, talk about your branded tours, talk about your office, your telephone number, your email address, all that stuff. You can do that in advertising remarks only in the MLS. Okay. All right. Everybody good? So in other words, your data is going in the MLS. Everybody understands that. Now there are some, I've had some people come to me and say, well, I don't want the public to know how much I paid for the house. And so, usually that's going to be my flipper, right? Somebody doesn't want anybody else to know that they're making a profit on it or whatever. I think those days have kind of died a little bit and gone away. And here's why. There's a couple of things. You got to go through 8 different steps to be able to not give the information in the MLS. Okay, like eight steps. It's tough. Okay, so they're gonna publish. They're gonna require it. I got it right now. I just input a listing that we just closed, and I had to put in the sales price. I had to put in the agents, other agents' information, all that kind of stuff. So that becomes public information as well. Okay, but what about the county? So when I sell a property, doesn't that get recorded at the county, and doesn't the county then publish that information? Okay, they do. All right. Oh, and by the way, there's a process for which you can ask the county not to put it in there, and it's also a very complicated process. Okay. But here at the end of the day, savvy guys like you and me, we're going to go in and we're just going to look at the tax stamps, and all we got to do is a little bit of math, and we can figure out exactly how much you paid for the house anyway, because we see how much the tax stamps were. Okay, so it's like, at some point they're going to figure it out. But so be aware of the fact that the contract is letting everybody know that the brokers are authorized to report this information to multiple listing service, including the sales price and terms and all that other kind of stuff. Okay, that's really kind of it. All right, so so that being said, let's questions on any of that. I'm going to take us to the next page. Yes, question. Okay. Oh, thank you. Yes. Jason. Hi, Jason. What time frame should a listing agent be required to change the status of for sale property to a pending status? Okay, so I'm not even reading the rest of your question. I will in a second, but I'm going to answer you easily. I did the new member orientations at SDAR until about 3 or 4 years ago, and then got taken over by Dan Hill, who does a wonderful job. He's really good with people. He's also on our professional standards committee. But I also did it at another association for a couple of decades before that. Here's the rule. This has always been the MLS rule. And by the way, this is the national model rule. So that says that you have 48 hours from all of the necessary signatures to put the listing in the multiple listing service. You have 24 hours for everything after that. Easy cheesy, right? Easy cheesy. So I got 48 hours to put it in the MLS after I have all the necessary signatures, okay? After everybody that's on title has signed it, okay? But then after that, pendings, anything else, solds, anything else that you do, you've got 24 hours to report it, okay? So that's just kind of a general answer. So that answers the first part of your question. For sure, 24 hours. I had an escrow. The listing agent waited 2+ weeks before he changed it from for sale to pending and still allowed showings for the property. Okay, so all right, so let me touch on that a little bit, and some of you are going to want to write this down. So you have an obligation as the listing agent to continue to market the property up to and including the closing date. Veronica Kilpatrick, well, again, I love Veronica, reminded us of that the other day in our meeting and said, you know, you've got an obligation. You're supposed to continue to market the property unless you have some written instruction from the seller to not do that. And by the way, she also mentioned that in new laws, okay, in February, all right, to the whole association. She said, you know what, you've got an obligation as a realtor or as a licensee to continue to market the property, because all kinds of stuff can happen. It's not sold until it's sold. I talked to so many agents who just come to a complete stop when they put a contract together. They think, oh, well, nobody would walk away from a transaction in this market. I'm sorry, that's not the most intelligent thing to be doing. I would keep marketing it, okay? Now, however, our MLS says that you must put it into pending status or contingent if there's a third party involved in the decision to sell, okay, within 24 hours. And when an agent doesn't do that, here's what you do. You send an email, you go into the MLS, you pull up the listing, you send an email to, you hit correction. There's a button up there at the top that says correction. It sends a private email, okay, to the rules committee. All right. And you just tell them, you say, hey, listen, contract date was X. Agent put it into pending at Y, and let them do their thing. I think the penalty is $150 a day. So it's pretty good spanking. So, we want to make sure that we remember we don't have a police force, and I am the chair of the rules committee. We don't have a police force looking for stuff. But when I hear stuff like this, that's not fair. It's not what our rules say. And so that's what I do. I turn them in. I get them all the time. For the longest time, I would get all these listings. Everybody has me on their mailing list. I'd get all these emails that say, not in MLS yet. I would go, thank you, forward. I would send it to my people at the rules, and they would look it up, and they would see that it not in the MLS, but we don't have an authorization to exclude, so which you needed to do, right? You have to put it in the MLS within 48 hours or get an authorization to not do that, signed by the seller. And that you need to send off to the rules at SDMLS. Okay, so it's a normal part of the process. If you've got a legitimate, signature from a seller to do that. Okay, but if you don't do that, then that's a ticket too. Okay, but we had that happen a lot. It was happening a lot for our people. Oh, unbelievable. Okay. All right. Now I have guests. Okay. But that was happening a lot. So the answer is that if they didn't change it for 2 weeks and you've got a contract date that says, here's when you had confirmation by the seller, send that to rules@sdmls.com and they will take care of the rest of it for you. And it's an anonymous complaint. They don't, call the person up and say, hey, so-and-so turned you in. Listen, if they do that, you please let me know. They're not going to do that. Kelly down there, Roland. I mean, we've got some great people at the MLS, and usually the first mistake, they get a warning shot. So the MLS will contact them and say, hey, you know what? You're supposed to be putting this into pending, and you didn't do it. I have had it happen where somebody got tagged in a transaction. In fact, they reported themselves as the selling agent or the buyer's agent, and then they somehow got a phone call from the MLS. And so they switched it over to me. And then, I go back and I'm just kind of looking around about 30 days after closing, they switched it back to them again. And so that was a big ticket because you were told, and then you reversed it after we checked it out. Okay. And remember, once you report it as sold, you can't touch the listing anymore. So, if you've got bad stuff in there, it's going to be in there for good until you're going to have the MLS fix it for you. So you better have a good reason to have it changed. Okay. So that may be answering the second part. still allowed showings. Yeah, we need them to continue to show it while we were in escrow. That's it. They should, okay? But they do need to put it into pending. Now, you and I both know that putting it into pending is going to reduce the number of showings, because a lot of people say, oh, well, it's pending, it's already gone. I think that's one of the biggest mistakes we make. You know how many properties I have sold that were pending? I sold one on was it Calais or Cordoba Cove in Del Mar. It had been pending for 6 months. I called the agent and I said, I got somebody for your place. And they said, thank God. I've been trying to get these people to sign cancellation. We brought our offer in, backup offer. They canceled the primary offer. I closed that deal. $425,000. That was an awful lot of money 20 years ago. Okay. So, understand how your profession works and know what the rules say. But again, if you ever have questions about that, email kevin@burkerealestateconsultants.com. I never turn people in for asking questions, right? I mean, when I turn them in, it's usually something that, that they're doing that's kind of crazy. But I'm here to help. And our MLS is here to educate. I mean, that's their whole job. They'll tell you, we're not here to ticket people. They don't make any money on the tickets. They don't care. Okay. All right. Speaking of tickets, let's talk about attorney's fees, unless there's another question. No. No. Okay. All right. Let's talk about attorney's fees. Listen, we all love to pay attorneys, don't we? Okay. So what am I saying? So here's how it works. If you don't have an attorney, and there's an old saying at law that says that an attorney that writes a contract that doesn't contain an attorney's fees provision is probably committing malpractice. You got to have an attorney's fees provision. Otherwise, you don't get your attorney's fees. And then it's going to be questionable. Okay. So our CAR contracts are put together pretty well. Attorney's fees. Let's talk about our attorney's fees provision here really quick. And I'll let you in on some secrets. So for example, if you've done a lease lately, you'll see that on the second to last page of the lease, there's a provision that limits the amount of attorney's fees to $1,000 or blank. And so part of the reason behind doing that was to eliminate a lot of egregious lawsuits. We have a lot of lawsuits that are happening, attorneys racking up huge fees. If we disincentivize that situation by creating a limit on the attorney's fees, we think we're going to suppress the number of lawsuits, because all we've done by limiting it is limiting the recovery by the prevailing party is what we've really done, right? So if we limit it to $1,000, and you can't write this language because writing this language is legal advice, right? But here we put it in the contract and we said the limit's going to be $1,000. Okay, so guess what? How many attorneys or how many people are going to sue the other side if all they can get, if they win, is $1,000? Okay, so that's not going to go very far towards their own attorney's fees. Okay, you follow me there? So if I had a case, God, it was a great case. By the time I got out of there, I think it was about 60 or 70,000 in fees. Each side had over $1 million in attorney's fees. And you don't think these things can rack up? Boy, they can rack up. And not necessarily through the fault of the attorneys. Trust me, they got plenty to do, right? Especially a real estate attorney, they got plenty to do. Okay, and we have some brilliant attorneys on our risk management committee that, I love them all. They're great. So let's talk about that. In any action, proceeding, arbitration between the parties, okay, arising out of this agreement, the prevailing buyer or seller shall be entitled to reasonable. Now, somebody define reasonable for me. So there's a principle of law called the reasonable man standard. The reasonable man standard is kind of like, I don't know, right? So remember, we have courts of law and we have courts of equity. The legal system in the United States kind of merges the two together, but the court of law says, here's the black line letter of the law. The court of equity says, it wouldn't be fair, right? Because courts of equity are concerned about fairness, okay, all right, which is, I don't know what that is. So reasonable attorney's fees, I don't know what might be reasonable to you, might not be reasonable to me, but that's going to be the reasonable man standard says it's going to be up to the court to decide that, because we're going to fight about it anyway, okay? Attorney's fees and costs from the non-prevailing buyer or seller, except that's provided in 22A. So you recall that 22A back there was my arbitration mediation of disputes, okay? All right, now, so is that clear? Everybody good? I've never, ever seen a lawsuit that didn't cost somebody a lot of money, Okay. And people complain about the attorneys, but really, it's like, why, the lawsuit was there. It didn't create itself. Okay. All right. Okay. Let's talk about assignment. Okay. So now our contracts used to not contain a provision regarding assignment. That's one of the reasons we had to put this in here, is because the law says that contracts are assignable by law. So they're freely assignable. Okay. And if you do commercial transactions, that, they assign contracts all the time. Usually the buyer assigns their interest in contract to someone else, or, sometimes you've heard them called like double escrows, things like that, where they just where really what they're trying to do is assign the contract before they take title of the property, so they don't have a taxable event. Okay, but contracts are freely assignable at law. All right. So what we had to do is we had to create a provision. We had to actually put it in the contract. And you know what, frankly, I'm surprised we got away with it as long as we did, where we've actually now created a provision that says, okay, we're going to address the issue of assignment. Okay. Because before, remember, buyer could do it anytime they wanted. Seller, people could do it anytime they wanted, right? Usually the buyer's the one doing the assignment. Okay. But let's talk about that. Now the provision in the contract limits the assignability of the contract. Okay. Now I've had this happen, and I'm sure I had a property down on 9th Street in Del Mar that I had listed, and the neighbor wanted desperately to buy this property. And the reason that they wanted to buy this property was because, they wanted to prevent people, from building a taller home in front of them. Right. And so they did everything they could. And these people did not get along. I mean, the owner of the property, the subject property, didn't like the ones that were trying to buy the property, and vice versa. And they would keep coming at the owner with a different name. They would come up with different parties and stuff like that. But at the end of the day, the owner knew, no, this is coming from the neighbor guy, and they were just going to sign the contract. It was kind of fun, crazy situation. This is 20 years, 20, 30, 25 years ago, at least. Okay. All right. So let's talk about what it means. Okay. Buyers shall not assign all or any part of their interest, because you got to have that language in it. See, now this is why you realize, maybe I should be writing legal stuff, because this is legal. This is good. All or any part. I didn't think about the any part. I could do a partial assignment. Wow. I didn't think about that. Buyer's interest in this agreement without first having obtained the separate written consent of the seller. So express consent, written consent of the seller to a specified assignee. Okay, so now if you're going to try to do an assignment, then you have to tell the seller who you're assigning it to. Okay, such consent shall not be unreasonably withheld. What do we say about reasonable? Reasonable man standard, unreasonably withheld. That's going to be, there's a lawsuit right there. Was it unreasonably withheld? So now the buyer comes along and says, I'm going to assign my interest in such and such a party. And we have a form, assignment of agreement addendum. We have that form in zip forms where you can assign your agreement to someone else. Okay, that's assuming there's already a contract in place, but we needed to get away from that language. The buyer's name is and or assignee. And we just decided the contract fails for vagueness. You got to specify who the buyer is. Worse yet, people were writing and or nominee, which is even worse than assignee. Okay, so we had to address this issue. By the way, CAR does a really good. They have a really good Q&A on that. I wish I'd thought to bring that up too. Somebody send me an email. I'll put the Q&A in there about assignment of interest into the folder that you're going to get later today. Okay, so such consent cannot be unreasonably withheld. All right, Pamela, is this regarding LLCs, Inc., and other entities other than a person or persons? So the answer is anybody. Okay, so for example, I'm buying the property as such and such estates LLC. We need to know that that person's authorized to sign on behalf of that entity, right? Okay, now they can go ahead and do that because they're buying it as the entity. But if I'm buying it personally and then at closing I want to really quick put in the name of another party, I'm prevented from doing that because I have to get permission to do it. The contract says that. Okay, Pamela, does that answer your question? Doesn't matter. LLC, Incs, doesn't matter. Trusts, sole proprietorship, whatever the name is that appears on the purchase agreement at the top is the name everybody goes by. Okay, that is the name of the buyer. So right there in paragraph number 1, the buyer's name is. Okay. And that's why we're really particular. That's why we ask the client, because in the old days, what would happen is the agents would say, oh, that's okay. We'll let escrow take care of it later. Please don't say that. Escrow is not going to take care of it later. Escrow may try to get people to amend the escrow instruction, but it doesn't amend your contract. So you need to address it in your contract. And that's why I always say, ask your buyer, how is your name? How do you want your name to appear on title? And then, because you're going to have to prove that you're that person, and usually the driver's license is pretty good, okay? And then remember that you also have to prove it when you go to sell it. So if you're buying a property for cash and you decide I can call myself anything I want, I'm going to call myself Mickey Mouse. Problem is when you go to sell a property, you're going to have to be able to prove that you're Mickey Mouse. Okay, so we want to make sure about that. Okay, why would someone assign something? Oh, they do it all the time. Again, they're trying to avoid a taxable event. They get such a great price on the property, then they run around trying to find a buyer for it before they buy it, and then they're going to make 20,000 or 30 or 50 or whatever before they even buy it. There's all that kind of stuff going on. We had this happen a lot back in the 03, 04, 05 when the market was just completely out of control. Real estate agents were buying property and then going out and advertising it against the rules, but they were going out advertising property for sale, hoping to have that, that long escrow, and then hoping to find a buyer for that property, within that extended period of time. The DRE takes very dimly that doing that. But we had a lot of that in 03, 04, 05. Boy, some of the things that we do over the years just stagger the imagination. Renee, sold a fixer, buyer sold it during escrow, someone else. Sure, they call that a double escrow. They have all kinds of great names. I don't care what they call it. Is it legal? Okay, so nothing illegal about it. They then filled out a form and let us know, and the seller accepted because they were much higher offers. This is the same thing. Sold the fixer and the buyer sold it during escrow. So in other words, before it closed, the buyer transferred their interest in the contract to someone else. I don't know why the seller, first of all, the seller got what they got, but I don't know. The seller can say no, and then they're going to have to close it. Or unfortunately, you might have told the seller who the second buyer is, and maybe the seller goes looking for that second buyer. One of the reasons I tell you not to fill out the cover sheet in the MLS or in the in zip forms, when you're looking at the cover sheet and you're looking at the buyer's names, you put in their name, you put in their email address. I wouldn't put anything else in there. Okay, so Renee, did I answer your question? Okay. Pamela, did I answer your question? Okay, I think I did. Okay, all right. And Pamela, you got it easy because you got me. Pamela, raise your hand. Thank you, Pamela. Question? Yes, thank you. Thank you, Renee. And I think Pamela's going to say yes too. Okay, thank you, Pamela. Okay, all right. So again, remember my language right here: unreasonably withheld. Reasonable. Listen, your takeaway on this paragraph is the reasonable man standard, and that's just a term of law. Okay. All right. Okay. And whatever reasonable is, I mean, I don't know. I might have a real hard time with what somebody else says is reasonable. Any total or partial assignment shall not relieve the buyer of buyer's obligations pursuant to this agreement. Okay, unless otherwise agreed in writing by the seller. Okay, so in other words, I can do a partial or even a full assignment, but the buyer is still responsible unless you have something in writing that says the buyer is no longer responsible. And if you look at your assignment of agreement addendum, you'll see that language. In fact, you know what a great question. Let's take a look. Happen to, sometimes I'm actually prepared. Where did I put it? Oh, shoot, I had to say that. Linda, not under that, not under that. And now I have lost it. I want to show you. There it is. Okay, here we go. All right, so here's my assignment of agreement addendum. Pay no attention to that up there. I'm teaching a law class, and so I've got a lot of lawyers waiting for me. Here's my assignment of agreement addendum. And in this agreement, usually California Residential Purchase Agreement is the culprit. Here are my recitals up at the top. It's either a partial assignment or a total assignment. Partial assignment adds a buyer. So like we just had a transaction close, and on the day of closing, the buyer's informed us they wanted to add Mrs. Buyer. So we could have done an assignment of agreement addendum, but I'm kind of old school. I made the buyer initial and sign everything that the first buyer had initialed and signed. So I essentially had a contract. It doesn't matter what the pre-printed language says, it matters the signature, okay? All right, and then what's the assignee's name? Because remember, you have to specify who it is, a specified assignee, okay? And then paragraph number 2 talks about acknowledgement that the buyer's already provided the assignee all the transaction documents previously approved by the buyer, et cetera, et cetera, et cetera. So this is actually a pretty good form. You know, I like it. Assignee represents for the benefit of the seller. The assignee ratifies and approves as the assignee's own acts all prior approval and acts of the buyer pursuant to the agreement. So, you know, you're going to have the buyer's name on here, and you're going to have the assignee's name on here, the person that they're signing it to, whether it's a total or partial. You would have specified that up towards the top, and then the seller would have to agree, or a seller would agree to it or not. But again, they could not unreasonably withhold consent. Is everybody good with that? So this is the form that you would use, for example, if somebody comes in later on and says, you know, we're going to add dad to the thing because we need dad on the loan in order to get the loan, and so we need to now add him to the contract because the lender's requiring it, and that's what you would do. I personally would rather go ahead and just have them sign and initial everything, because it's not going to be good until the seller initials the change anyway. But that's just how I do it. I'm a little old school that way. Okay, but that's the point behind the form, and frankly, pretty good form. I like it. Not that in my opinion matters, but you know, I'd be using this. Okay, all right. That being said, let me go back. Whoops, question. No, got it. Okay. Let's go. Oh God, now I got that. Okay, that goes there, and then let's go back to where we are. All right, so that is my assignment, and I've already spilled the beans on the rest of it. So shall not relieve the buyer's obligations pursuant to this agreement unless otherwise agreed to in writing by the seller. And there it is. That was my AOAA form. And so as I pull that form back up again, here it is. This is my AOAA form. Okay, everybody good? Okay, all right. Let's go back then to where we are. That's going to finish off that part. And then we're going to get into the home stretch here. Now we're going to be talking about, and I do classes on fair housing, and it's not, you know, it is different depending on where you go. So here's my equal housing opportunity. And listen, folks, we must be in compliance, not only because the law says it, but because it's the right thing to do. Okay. And so when I'm teaching this class in Virginia, for example, you know, I go crazy about this stuff. I've been asked to teach fair housing classes across the country, and this is near and dear to my heart. So it's not in the contract because the law requires it. I think it's in the contract because it's the right thing to do. So the property is sold in compliance with, now this is the important part, federal, state, and local anti-discrimination laws. Okay, and that's in our contract. And so where do we see those things? You would be amazed if you looked up property that was in San Diego County. Look up any of the developments. Look up what the house was that was there originally. Look at the rules associated with it. You will see some things in there that you are just going to go nuts. It's like, what? It said that? I mean, you know, we can't sell to this religion. We can't sell to this race. We can't, you know. Get me started. Okay, so this paragraph means a lot to me, right? So, you know, I invite you to go look at some of those things. Look at Rancho Santa Fe. Some of the things that we've done to each other, I think, is just horrible. So let's try to remember that. Okay, all right. So again, I don't think it's in there just because the law requires it, although the law requires it, but also because it's just the right thing to do. Okay, all right. Let's talk about paragraph number 20. I could do a whole class on that. You got 3 hours. So let's talk about paragraph number 28. Okay, terms and conditions of the offer. So, and this, I love this paragraph because there are like 3, 4 really important principles of law. All right. So when I'm teaching this to the attorneys tonight, it's like this will be a whole nother class, whole different class. This paragraph, I could spend hours on it. Let's talk about it. This is an offer to purchase. It's an offer, okay, to purchase the property on the above terms and conditions. So all the stuff we said in paragraph number 1 through paragraph number 27, this is an offer to do that. This paragraph is specifically put here because this is the summation of the whole thing, okay? The liquidated damages, now this is going to answer questions I've had probably 5 different people in the last 2 weeks. Liquidated damages paragraph or the arbitration of disputes paragraph is incorporated in this agreement. Now watch this. You all are you're just going to go nuts, okay? If initialed by all parties. You got that? So what happens when you get your offer and the buyer has skipped over it, because remember it's an optional initial in liquidated damages and in arbitration. Remember what I told you before when we discussed arbitration and liquidated damages? Hey, that's a personal decision for your client. Don't be forcing them to do that. That's why we changed the fields in the electronic signature platform. It used to be a required initial. And, I don't know, I was possessed by demons. I said, why are we requiring them to do that? First of all, liquidated damages, I probably wouldn't sign liquidated damages provision in this market. And they go, oh my God, you're right. The seller, if the buyer defaults, the seller sells the property for more money. There's no damages. Right? Okay. So that's just my argument. But again, parties do what they're supposed to do, what they want to do. Okay. But by the way, follow the advice of your broker. The problem is that we've been teaching you over all these years that they should initial everywhere there's a place to initial. And yet these 2 paragraphs are powerful. Okay. Arbitration. Listen, I wouldn't initial arbitration. I like going to court. Right? Okay. Crazy. I like going to court. But it's your client's decision, not yours. So why are you requiring them to do it? So check with your broker, get your broker's advice. Do we want them initialing liquidated damages? Do we want them initialing arbitration? But you have to understand the concept. So we did 21 and 22 were a whole hour on their own, hour and a half on their own. So if you want a copy of that part of the webinar, email education@sdar.com. God love them. They'll send you a copy of the webinar. You probably should look at that one. That was a doozy. Okay. And again, when I do liquidated damages and arbitration, it's several nights in the continuing ed with the attorneys. Okay. At 3.5 hours a night. Okay. All right. Okay. So it is incorporated if initialed by all the parties or if incorporated by mutual agreement in a counter offer or addendum. So buyer misses it. Whenever the buyer does an initial 21 and 22, I call the buyer and I say, did you intend to skip it? And they say, oh no, it just, once I went past it, it wouldn't let me go back. Okay, so you did want to initial those paragraphs? Yeah, okay, well then we need to fix that, okay? But the seller can also fix it, right? So how does the seller fix it? The seller fixes it in a counteroffer or in an addendum. But if they're not initialed by all parties, so the buyer's agent, the buyer says I'm not going to initial. I had a buyer who was an attorney, and he says I'm not going to initial arbitration. And I said okay, I agree with you, right? So I'm not going to initial it. Says I like going to court. He goes I like going to court, and it's my sandbox. He says he actually said that. That's my sandbox. I go okay, great. So offer goes over to the other side. Listing agent comes back and says the seller's going to not sell it to the buyer unless the buyer initials that paragraph. Now, seller wasn't aware. We have to disclose our licensing status. We don't have to disclose our lawyer status. Isn't that funny? So I don't have to tell you I'm an attorney, but I do have to tell you I'm a broker. Isn't that kind of crazy? So that's the way the rules are. So if what happens if you don't do it? What happens if you don't have consensus? Therefore, you don't have a meeting of the minds, right? Buyer doesn't initial it, seller does. Now what happens? If at least one, but not all of the parties, I'm sorry, back up. If at least one, but not all parties initial, okay, a counteroffer is required until agreement is reached. What does that mean? That means if you don't initial it, the provision doesn't apply, right? So if you want it to apply, all parties have to initial it. But if you don't, and this is where the listing agent needs to watch your contract to see whether or not, the buyer has initialed it. If the seller wants it to apply, then the listing agent needs to be looking at that part of the contract to make sure whether or not the buyer has done that. Okay? Because remember, if the buyer doesn't do it, and the buyer doesn't do it on purpose, then, and the seller wants it, then you don't have a contract until everybody agrees to either remove it or to put it in place. Does everybody follow me on this? This is a critically important conversation, okay? So you're gonna have to address it. You're gonna have to address it in a counter offer. A counter offer is required until agreement is reached. Everybody okay with that? Okay, all right, good. Okay, well, by the way, seller has the right to continue to offer the property for sale and accept any other offer at any time prior to notification of acceptance. Okay, so remember that you have offer, okay, you have acceptance, but then you must have communication, you must have delivery to the party to be bound. So counter offer's fine, okay, but you have an offer, and then you have the seller accepts it, but doesn't tell the buyer about it, no contract, right? Because there's no meeting of the minds. The buyer's not aware they have a contract, okay? You got to tell them, okay? And the same thing applies to this paragraph. That's why I just think that's the best thing. I told you this paragraph's going to be full of all kinds of cool stuff, okay? All right, now I'm sensitive to your time. I'm watching the clock. Okay, all right. So parties have read and acknowledge receipt of a copy of the offer and agree to the confirmation of agency relationship. So we had to say that again. So remember what I told you before. 21 and 22 require separate initials. Okay, liquidated damages arbitration. The other initials at the bottom of the page don't create the contract. So I have people that come back and they go, well, we don't have a contract until your buyer initials the bottom of page 5. It's like, sorry, the buyer and the seller have both signed page 10. At this point, 10, it's going to be 13 next year. Okay, but they have both signed. I think that's what makes the contract. I don't think that the initials, and I'm not going to give you legal advice, but I don't think the initials at the bottom of the page is evidence anything other than the fact that they've seen a copy of it. Think about it, okay? Okay, I'm going to tell you, I don't give you legal advice. I think that's legal advice. Okay, so let's be careful. Okay, now, yeah, should we get the initials? Yeah, but once there's a signature, I think my contract's done. Okay, and so the TC that tells me that there's no contract is probably going to need to take another class. Okay, all right. Okay, and by the way, we need to say again, we are confirming agency, okay? Because remember, the law says that you must disclose the concept of agency. So when you're representing your seller, you do an agency disclosure with the seller, which says that now I'm disclosing to you what it looks like for me to represent you. And then if in the event we become a dual agent, this is what it would look like as a dual agent, right? And then conversely, the same form is used. We've changed the heading at the top, but the same form is used by the buyer's agent. They say to the buyer, at this time, I'm signing you up for the buyer representation agreement. I don't know if I'm going to be a single agency or a dual agency. And again, I do trial work on this, and you want to bet they're going to spin you around. So you need to know this concept, okay? So the concept of agency is critically important, all right? So agency here is the same as agency in Virginia, the same as agency in Idaho. Listen, agency is agency, okay? There's some variations to the theme like designated agency and stuff like that. I don't want you to worry about that. In California, we only think in terms of either I'm a single agent or I'm a dual agent. So I disclose agency, the concept of agency at the time of my listing and the time of my buyer representation agreement, but then at the time of my purchase agreement, paragraph number 2, I need to confirm agency. And this was another great conversation that came out of Veronica Kilpatrick. And this one's probably about 8 years ago in a meeting that I had with her. And she said, y'all finally moved it. Actually, it had to be longer than that because we changed it in October of 12. So it was 8 years ago. And I guess I was right. And Veronica said, yeah, y'all had it back there on paragraph number 26. Nobody ever filled it out. So you all never confirmed agency, which means you were all breaking the law, okay? You must disclose the concept and then you must confirm. Okay, so that confirmation is critically important, and that's why we moved it up to paragraph 2 of your RPA. So now you're right there in the middle of it. You can't miss it. It's the second paragraph. Okay, and yet we find people all the time mess it up. They don't check the box. They don't do the name right. You know, whatever. We are all in our template. We're sending out the AC form, which is the confirmation of real estate agency relationships, because usually the purchase agreement is messed up. Okay, none of you would do that because you've had these webinars, right? But at the end of the day, I must also confirm agency, and I'm going to just say it 3 times in the purchase agreement, okay? If this offer is accepted and the buyer subsequently defaults, buyer may be responsible for payment of the broker's compensation. Okay, and so what do we always say? I never say you will lose your deposit. I've never said that. I will always say your deposit is at risk. And so here I am. I'm looking at the similar type of language. Buyer may be responsible for payment of broker's compensation. So, you know, that's going to come in when you read your buyer representation agreement. You saw that if the purchase of the property is interfered with by the buyer, that the buyer may end up paying compensation to the agents, right? So, you know, because you did it. Okay, if someone other than the buyer causes it to happen, then that other person might be responsible. But if the buyer recovers from that other person, then we are entitled to a portion of the buyer's recovery. Same thing applies with the listing. So the seller, if the seller prevails against the buyer, then the brokers are entitled to a portion of the recovery. It's either going to be half of the recovery or limited by their commission, whatever that would have been. So those are important things to know, and your buyer needs to understand that as well. Okay, everybody good? Okay, good. All right. Okay, now let's talk about okay. The last thing we're going to talk about, this agreement, okay, and any supplement, because remember, you can amend a contract, right? Addendum or modification, call it whatever you want to call it. If you change the terms of the agreement and you have to change it officially, remember what I said to you earlier? You call escrow and you ask them to draft up an amendment. I'm sorry, folks, we stopped doing that about 15, 20 years ago. So if you got that advice from somebody, that's somebody that's living in an old world, okay? Because you need to amend the contract between the parties. And when escrow sends, if I get involved with it, listen, my escrow companies are trained, right? They know don't move without Kevin looking at this first, okay? And the idea being that you can go ahead and amend your escrow instruction. Now everybody thinks that they're okay, but they're not okay because you didn't amend the contract. You only amended the escrow instruction. So you only amended what the escrow is concerned about is to tell us what to do, right? But you didn't amend the contract. And so then you get sued on the contract because escrow amended it, and escrow is going to go, oh, no, we get it. We're not messing with that, okay? We're not going to amend we're not going to, if we amend our escrow instruction, we need you to give us that amendment. So we created in our contract, okay, we use the addendum. We don't actually have an amendment form. We actually call it an addendum. It should be called an amendment because remember, an addendum adds to things, an amendment changes things, okay? So those are pretty significant principles of law, but we only have an addendum form. We don't have an amendment, per se, like we have the addendum. Okay, including any copy. So the agreement and any of these things, including a copy. So remember, used to be in the old days, we had to sue. You had to have the original to sue, right? So you sued on the original. Copies didn't work, okay? And we had to change that language. We had to say, okay, copies is good. God, today, folks, you can make a copy better than the original, right? So, we had to change our language. So including any copy may be signed, and you're going to love this. This is so good. Those of you who've been my students in the college, you know, this is part I get aside. In 2 or more, what? Counterparts. So what is a counterpart? So if I have one document right here and I have a second document right here, I have the buyer on this one, the seller on this one. If I can hold the 2 documents up to the light, we call it the light test. I hold it up to the light. It's the identical document with the exception of the signatures. Then it's going to be binding on the parties. All right, okay, it's called the light test. It's a principle of law versus the laugh test. The laugh test is where you're sitting in court and the judge is looking at you trying to enforce a fact that's like 8 generations old, and the judge starts laughing uncontrollably. Listen, I've had judges laugh in court. When you see the judge laugh, now I can make them, I don't try to make them laugh because it's serious, but boy, when a judge starts laughing in court, oh, everybody puts their head down and goes, uh-oh. Somebody's going to get hurt. So and I've seen judges, Linda doesn't even know this. I've seen judges in court. Take my word for it. It's not good. They start laughing. So, but signing it in Counterpart means I've got two of the identical documents. The only thing different, they go up to the light, they're the same document. The only thing different is the signatures, then it passes the light test. So I've signed in two or more counterparts, all of which shall constitute one and the same writing. Bingo. Right? They're going to be the same thing. Okay. So, this goes back to the day when, we would send the originals around, have everybody sign it. We'd have to fight over he who writes it keeps it. It's like, I would write the offer. I'm entitled to my original, with wet signatures back. Well, today we do things electronically, and it's easy enough for us to prove whether or not it's the same document. And I have had trial work on that. One of the reasons that you're no longer able to put a date next to a client's signature is because, I had a case where the agent had falsified the signing date, right? Because it was something that had to have happened earlier and they didn't do it. And so now later on, they're essentially forging next to the client's signature. And so, that's another one came up in the zip forms meeting. And it's like, we gotta stop agents from doing that, and sometimes to protect themselves, because we like to double click on the link and it automatically pops up the date. And it's like, yeah, I know, but that's not the date they signed it. And you need to have it on the date they signed. There's no reason to post date. There's no reason to predate in a contract. If you're doing it, you're probably going to run afoul of something. Okay. All right. That's good. We covered some good stuff. We really did. We covered a lot of really good stuff. And take care for now. Okay. You all be good. Bye-bye.
Need more help? Contact SDAR Member Services at 858-715-8040 or membership@sdar.com.